It's fair to criticize Fulton County DA Fahey Willis' prosecutorial judgment in asking the grand jury for that 41-count indictment charging former President Donald Trump and 18 others. I've been critical of her. For starters, how can she in good conscience send anyone, rich or poor, to that Fulton County jail with its deplorable constitutional violations? And why hasn't she done anything about it? And don't tell me she did not know. It's impossible for her as DA not to have known. I'm also highly critical of her for pushing for a trial date before any of the 19 defendants has been booked and arraigned. I think that's grossly unfair to defendants. And we all have a First Amendment right to criticize her for that and how she handles prosecutions. But a threat is different. That's a crime. It's a crime to threaten her or anyone else. Anyone who threatens another person should be charged and prosecuted. Which brings me to this. Just like threatening a DA, it is a crime to threaten grand jurors. Right now, that is happening. The grand jurors in this case are being threatened. The online edition of The Hill reports the threats include: everyone on the jury should be hung. I see a swift bullet to the head if and when somebody shows up at their homes. Awful nice car you have there. Hate to see something happen to it. Those are just some samples of social media threats. Making this more alarming is that under Georgia state law, the names of the grand jurors are listed in the indictment so people know who they are. So why the threats? You know why. The country's on fire politically, and many people have no tolerance for views other than their own. They take their rage out on others, including this grand jury. Sometimes that rage results in a threat. That's always a crime. Sometimes in an insult, which in this instance is wrong. The system puts grand jurors between a rock and a hard place. Some time ago, each one of them received an order, not a request, but an order to show up at the courthouse on a certain date and time to serve on a grand jury. Mailed grand jury notices to appear. They don't tell the person what case or who might be the target or targets of the grand jury. It essentially says, show up or else. And what's the or else? Well, if you don't show up, you're going to be held in contempt of court, fined to jail. So they show up as good citizens are supposed to. On day one, they take an oath to do their best job. They're told the job of a grand juror. And that job is to consider and weigh all the evidence, witnesses, and all physical evidence like pictures, texts, emails, etc., presented to them by the DA. The DA in this instance is Fulton County DA Fahey Willis. There are no defense lawyers in the grand jury room, only the DA. That obviously means grand jurors only hear the DA's version of events. And of course, every DA believes the targets are guilty or they would not be there in the first place asking for an indictment. Grand jury proceedings are 100% controlled by prosecutors, are 100% one-sided. Trials are different, very different. They are the first time the defendant and defense counsel are present and can defend themselves. Grand jurors aren't even asked if a defendant is guilty, just if it's likely a crime was committed and committed by the person. The DA says committed a crime. Just likely? Yes. And if yes, that's an indictment. Under Georgia law, not all 23 grand jurors even have to vote yes for the DA to get an indictment. Only 12 grand jurors need vote yes. And that standard, likely or probable cause, is so slim. It's a very low standard of proof. That's why you often hear lawyers saying a prosecutor can indict a ham sandwich. At trial, where the defendant is present with his lawyer for the first time, the standard of proof is high. It's beyond a reasonable doubt. And consider this. It is theoretically possible a grand juror would vote to indict, since the standard of proof for indictment is so low, but if called to serve on the same case at trial, and where for the first time hears from the defense, and where the burden of proof is so high beyond a reasonable doubt, might vote not guilty. Now, you know from your own experience, when you hear the entire story, not just part, like in a grand jury, it can look a whole lot different. The Fulton County grand jury did its job. It voted, after hearing only part of the story, what the DA chose to present to them. That is how it is done everywhere. What did this Fulton County grand jury get for doing its job? Threats and insults. Now, you may hate this indictment. You may think it's unfair. By intimidating citizens with threats and insults from ever serving on grand juries is not only a serious crime, but it's so destructive to our already flawed system of justice. United Kingdom Prime Minister Winston Churchill said, in part, quote, "Democracy is the worst form of government, except for all those other forms that have been tried." Now, the same is true of our jury system. It is far from perfect, but do you have a better idea? And if it turns out that DA Fahey Willis is unfair, making judgments based on bias or occurring favor, just vote her out of office. But don't blame the grand jury. Don't threaten them. Former Assistant U.S. Attorney for the Eastern District of Virginia, Jonathan Fahey, joins me. Disagree or agree?
I agree with what you said. The grand jurors are doing their part, and they should not be criticized, threatened, harassed in any way. It really was shocking to me that they actually published their names. I didn't think that was something that was ever done. And you would think on this type of case, they would have taken safeguards to make sure their names were not publicized. But you do look at the last few years with the judicial system, you look at the protest and the doxing of Supreme Court justices, and that's almost been accepted. And it does seem like this is going in a very bad direction. And we really should respect the process, respect the grand jurors. And again, they're not the ones that are making the calls on this. But even if they are, we respect the system, respect the process, and threats are out of bounds. Harassment, all of that should be off the table for both sides.
You know, I mean, it's Georgia law that permits those names to be listed in indictment. I'd never seen anything like it either. When someone told me it's in, I said, no, that can't possibly be true. I mean, I've just never seen it. But in this instant, wouldn't you think that somebody would have had enough sense to seal that portion of the indictment, to ask to have it be sealed if it's mandated by Georgia law? I don't know if it's mandated or optional. I mean, they were stupid enough to put it on the, they posted it before the indictment was even voted on, so that was, you know, mistake number one. But then, I mean, wouldn't you think someone would have enough sense to protect these grand jurors?
Yeah, you would think they would at least seal it, or at least move to seal it, and then let the media or other people who would demand it to be unsealed to sort of fight that battle in court. But there really is no public interest in knowing these people's names, and so they could be looked up, because again, they're just part of the process. But it does surprise me, when that was one of the first things I noticed when I read the indictment, was that they had their names there, and that's something I've never seen before. And there's really no public interest in their actual names being out there.
Looking at that indictment, it's a hefty one. Your former federal prosecutor, any thoughts about it?
I think they have they have some real problems being in the state of Georgia. You know, if you look at that motion that Mark Meadows filed earlier this week, this motion to remove it to federal court, I think that has a very good likelihood of succeeding on both fronts. One, having it removed, and two, having it dismissed. Because under the supremacy clause of the Constitution, you know, a federal officer or a federal official acting in their capacity, if they're doing what they reasonably believe is part of their official duties, they're immune from prosecution. So that means the case should be dismissed. And he's the only government employee in that instance, except for the president, I guess. Except for the president, but I think there's a very good argument that these other conspirators or co-conspirators allege could be agents of the president, because he's essentially atop this conspiracy and this allegations. So they should all join in that motion to have it brought over. But even if it's brought over with Mark Meadows, the whole case comes with it, unless there's some severance motion by the DA or something else. So that case goes to federal court as a state case. You know what I thought was shocking about the indictment involving Mark Meadows? It listed in the count, the one that I read, it said that essentially that Mark Meadows was in the room on January 2nd when President Trump had a phone call with the Secretary of State of Georgia, and then it says the overt act, which is the basis of it. It was listed in the indictment, so you had to go to another part of the indictment, and then you read what the overt act is, and it says all these statistics, like dead people voted, and all these statistics, which they said was a lie to the Secretary of State. But it said President Trump said it, not Mark Meadows. So where was his overt act? He was just sitting in the room. Well, yeah, some of the things are quite remarkable in that indictment. I mean, some of the overt acts are Mark Meadows wanted to watch votes being counted, or wanted them to hurry up and count votes. These seem like very appropriate things for him to be doing when he's challenging an election, and it's not out of bounds to challenge an election through the legal process. So some of those overt acts were quite curious. I don't think it helped the optics of this indictment. Whether or not how it ultimately plays out, I don't know, but certainly it doesn't make it seem that serious when they're looking at things that are not that unusual and don't seem bad. What's the message when the prosecutor seeks a trial date before the defendant's even been booked or arraigned? I think what she is doing is basically covering herself for speedy trial claims, saying we're ready to go early, so then they later can't say they didn't have a speedy trial. She doesn't want this case to go to trial. She'll be happy as a clam to have this go after the other cases. She had her moment in the sun with this case. I would love to find a time that an 18-defendant case ever got tried within essentially 6 months in Atlanta or anywhere else. Jonathan Fahey, thank you. Nice to see you. Thank you.